May it please the Court.
Good morning, Mr. Campbell.
Good morning. I stand before this Court as counsel for Tatiana Saab and Mark Giambrone, who are the next of kin of their deceased son, Christian Giambrone. The action was filed on their behalf, and was brought in the name of the estate of Christian Giambrone, but the action is in fact personal to his next of kin. The Superior Court heard motions to dismiss based upon Rule 12b-6 for failure to state a claim upon which relief could be granted, and Rule 12b-1 for lack of subject matter jurisdiction. That motion was allowed. The plaintiff filed a timely appeal and requested direct appellate review by this Court, which was granted. The issue before this Court, however stated, is whether the exclusivity of remedy provisions of General Laws, Chapter 152, Section 24, recognizes and preserves the right to a civil action by parents in their capacity as next of kin of a deceased child where they were not financially dependent on him and therefore ineligible for any compensation under the Workers' Compensation Act, did not receive any compensation, and where the deceased child was killed in such a fashion that he was ineligible for any wage or disability compensation under the Workers' Compensation Act.
Why doesn't Germain versus Pendergast just answer the questions here? I mean, are you asking us to reverse Germain versus Pendergast?
Germain versus Pendergast involved a fellow who was catastrophically injured, received substantial compensation benefits in the nature of a wage replacement, in the nature of disability.
This is the employee.
The employee, the son who was dependent on the parents. The parents, living with that dependent son, enjoy the benefit of those compensation payments made to their son.
But were those payments? Was it necessary that the son live with the parents to get those payments? I mean, those payments would have been paid no matter where the son lived.
I think the underlying logic of the workers' compensation statute is that benefits, financial compensation, is delivered to the employee. Mm-hmm. Those compensation types are there primarily to replace wage or disability. And in the setting of a family, the family members enjoy, at least indirectly, those benefits.
But the parents weren't dependent on the son, just as
No, just the opposite.
The parents were financially dependent on the son in Germain?
No, I misspoke. In Pendergast, as here.
Right, same as here.
The parents were not dependent on the child. It was just the difference between the Pendergast case and this case is that in Pendergast, substantial compensation was delivered to Pendergast.
But, Mr.
In our case, I'm sorry.
No, you finish. In your case, I understand there was, I think the record would suggest that there was the funeral expenses. There seems to be a dispute, but I take it there's some evidence that the funeral expenses were paid by some version of CVS and reimbursed by the insurer. Is that not so?
There is a statutory provision for funeral expense up to $4,000.
But it's part of the workers' comp statute, isn't it?
Yes, that was. In fact, that was never paid. But that right, that theoretical right to get up to $4,000 of a burial expense existed. There's no contest to that.
This is the question I wanted to ask you.
Yes,
I'm sorry. I'm having trouble, and maybe you can explain it to me, why Section 24 doesn't, what do you do about the language in Section 24 that says if an employee has not given notice to his employer, which is your case, then the spouse, children, parents, any other member of the family, oh, I see. You say that doesn't apply because they're not wholly or partly dependent.
This case, this court, I think in the Russell case,
okay. I'm sorry.
Looked at the statutory language at hand in Section 24.
Okay.
And I'm sorry.
No,
I don't mean to cut you off.
No. You go ahead.
I take it your position is really quite straightforward, at least as I understood it, whether or not I agree with you. But tell me if I've got it right, Mr. Campbell. Workers' comp is a statutory mechanism that was designed to remove, in order to protect workers and those who were dependent on them from the vagaries and fluctuations of having to commence personal injury cases. In exchange for that, they have a system in place where, burdens are shifted and so on as laid out in the statute. That's for workers and those who are dependent on them, because it was essentially, in crude language, a sort of wage replacement, correct? For people who are not dependent on them, there may be causes of action which we may have recognized at common law. I mean, we let parents sue on behalf of their deceased children who may or may not be workers. That's a common law thing. And the workers' compensation statute, as I understand your point, was not intended to eviscerate all of those claims. The linchpin here is dependence, correct? Do I have it?
Financial dependency is the linchpin,
Sure.
and it is not a linchpin that is invented by us or by our clients. It's a linchpin that was put into the statute, Section 24, by the legislature following the Ferretta decision.
But didn't, and I'm not going to remember which case, but isn't there a case that says that the language about wholly or partly dependent just modifies next of kin and not parents?
Well, it actually says that that language modifies other family member,
Right.
any other member of the employee's family or next of kin.
Right.
So put it in the context, if I may, Your Honor, put this in the context of a comparison between a work-related injury that results in a serious injury to a worker, make the worker a child, make the child dependent on his parents, like in Pendergast, and compare that to a work-related injury that produces a death under very short time circumstances where the worker who dies under short time frames is dependent on his parents, like in Pendergast. Compare what is recoverable in the circumstance where the worker survives versus what occurs when the worker passes. When the worker survives, a full panoply of workers' compensation benefits is provided. The family members, and hence the reference in Section 24 to spouse, child, or parent, the family members indirectly benefit from the availability of that compensation to the surviving injured worker. Now compare that to our case. In our case, Christian Jambrone exsanguinated on Longwood Avenue. He received no medical treatment. His transport ultimately was to the morgue. Under extant workers' compensation law at the time, Christian Jambrone was not entitled to compensation. Christian Jambrone's estate, as an estate, was not entitled to compensation. And Christian Jambrone's parents, because they were not dependent upon him, were not entitled to 1 farthing of workers' compensation payments. And in fact, they received none. Nothing at all. Now, fast forward to that statute. That statute which was interpreted in the Russell case,
Right.
and which was found by this court to be clear and unambiguous by this court. That statute provides that, in concert with what had been workers' compensation law for a long time, that an employee who doesn't provide the requisite notice has the exclusive remedy under the workers' compensation statute. That's the effect of the language. But the statute then goes further. If the employee does not give notice, Christian Jambrone, when he was 16 years old and took this part-time job, didn't give notice. If the employee has not given notice, the statute, the legislature then deemed that the employee's spouse, children, and parents shall also are held to have waived any right created by statute and common law, and then goes on further to say, any other member of the employee's family or next of kin who is wholly or partly dependent upon the earnings of such employee at the time of injury or death shall also have been deemed to have waived their common law and statutory right. Now consider the way in which the statute was put together and the timing of it after the Ferretta case. When this court in Ferretta upheld the rights to claims for loss of consortium, and the legislature then amended Section 24 to include this specific language. And also consider, if you will, consider that at the time they're adopting this language, the legislature knew that family members and next of kin who were capable of establishing that they were wholly or partly dependent financially on the decedent might have a right to compensation benefits. They might. The legislature knew that. The legislature as well knew that family members and next of kin who were not wholly or partly dependent financially on the worker would have no right. The only way to look at that language and make sense of it is that the legislature had that in mind, that under the workers' compensation law as it existed then and now, family members and next of kin who were financially dependent in whole or in part would have a right to workers' compensation benefits, but if they were not wholly or partly financially dependent on the worker, they would have no right at all. And so the legislature, in crafting this exclusivity of remedy provision, accepted out those family members or next of kin who were not wholly or partly dependent on the worker.
I take it, Mr. Campbell, that the
Yes, sir.
natural result of, if we agree with you, is that let's take a 40-year-old worker, you know, who hasn't waived. I mean, there's no claim that he was, 16 and didn't know about the statute. It's just the normal, typical worker is killed. I'll take the death situation. Then anybody who is not dependent, or any entity that is not dependent on that worker in whole or in part, has any claim that it may want to bring against the employer?
The way you put it, the answer would be yes, if they had a viable claim and they are exempted,
Yes, that's
accepted
what
out of the statute.
Well, they're not accepted out of the statute. I mean, and that's what I was trying to pose the hypothetical. You're saying the workers' comp statute and the balancing between the rights of the worker and the rights of the employer and so on and so forth, I mean, the whole history of the workers' comp really covers all claims of the worker, and for these purposes, anybody who's dependent in whole or in part on the
Yes.
worker. And then once you are outside of that, all other causes of action, they have to be legitimate causes of action, survive against the employer.
That's right. The exclusivity of remedy provision would apply as you describe it, given the language that the legislature used, selected, and crafted here. This is the language
This language has been around a long time, right?
Well, with the language that is the subject matter of our discussion right now, I think that was new post-Ferreta in '85.
Yeah, I know.
I could be wrong about that, but this is the first time that I know of.
And lots of consortium claims are not unknown or unheard of, correct?
No, they're not.
I mean, in fact,
if
almost
I might say this, and direct your attention to the Green versus Wyman Gordon Company case, 422 Mass 51, the standard that applies in a circumstance like this was set forth, and the court said that the court construes statutes to be consistent with one another, particularly when they deal generally in the same subject matter. The court went on to say, we attempt to interpret statutes addressing the same subject matter harmoniously so that effect is given to every provision in all of them. And if you take that as the standard and how you are to address this statute and other statutes that relate to injured or killed workers on the job, you must try to meld them together and interpret them harmoniously so that effect is given to every provision in all of them. The effect that has to be given, I submit, in a circumstance like this, where the next of kin, parents who become the next of kin when their boy dies on a sidewalk, the next of kin receive nothing under the workers' compensation benefits, nothing, then under those circumstances, this court should, interpreting all of the relevant statutes together, give meaning and give animation to the language in Section 24 and find that the exclusivity of remedy rule doesn't mean an exclusivity of no remedy rule.
Aren't you really trying to extend the reach of the statute?
You're trying to cabin the reach of the statute,
I
right?
suppose it's a half-empty,
I think
half-full
you're
way
cap-
of looking at it.
you're
I'm
cap-
trying to, I see my time is up, but I will say this. I'm trying to protect the rights of a mother and father who lost a kid and who received no benefits whatsoever. That's my job. That's the only reason I stand before you. Thank you for the time.
Thank you, Mr. Campbell. Mr. Daly?
William Daly and Miles McDonough representing Massachusetts CVS. This company is the successor to Longwood CVS, which was the employer of Christian at the time of this most unfortunate incident. And if it's all right with the court, I'll simply refer to the entity as CVS and to the decedent with the most respect as Christian. We're asking that this court affirm the judgment that was entered after the trial court ruled on the 12B6 motion that was filed early on. That motion was filed under both sections 1 and 6. There are a number of facts that are not in dispute and are not contested. One being that Christian was an employee of CVS. Second being that CVS maintained a workers' compensation insurance program. The third being that Christian did not retain his right to bring a common law action. The fourth being that the injuries occurred within the scope of his employment and in furtherance of his duties as alleged in the plaintiff's own complaint. And the last, fifth point being that the injuries sustained and the resulting death were compensable. The cases all indicate that the important factor in these matters is whether or not the injury is compensable, not whether or not compensation was paid.
So it was compensable because it occurred, it arose out of and in the course of his employment.
That's right. The plaintiff's position is weekly indemnity was not paid, and therefore there should be some exception made to the exclusivity bar that is raised by the Workers' Compensation Act. Larson, as we mention in our brief, indicates that there are classes of cases where at common law you may have a very substantial recovery, but under a Workers' Compensation Act there may be no recovery.
Mr. Daly, could you help me with this? I understand the compensable versus, no compensation was paid. But if I look at the language of the statute, and I'm sure you've looked at it in many, many contexts, I see an employee shall be held to have waived his right of action. Fine, so that's his. And then you go down, if he's not given notice, you get to the employee's spouse, children, parents, and any other members of the employee's family or next of kin who is wholly or partly dependent upon such earnings. Isn't that a limiting clause?
Skipped one section, Your Honor,
Right.
and that very important distinction
Okay.
has been addressed by the court in the Russell case.
Right.
If you notice, the employee, his spouse, his children, and parents are referred to initially. And then it goes on to talk about other family members and next of kin.
I see. I understand. I get what you're interpreting.
Yeah, and the court made the observation that the word is a singular, obviously referring to the next
Next
of
of kin,
kin.
okay.
Right.
Mr. Campbell's argument, I take it, is that his clients were parents while Christian was alive and became next of kin on his death.
That's right. Right.
To get
But-
into the, yeah.
But there was an injury. At the time of the injury, they were parents. They may have become next of kin subsequently, but certainly for the purposes of the statute, they were parents. Also, this court in the second McDonough case, I think it's in volume 448, makes reference to the fact that although we have frequently recognized that the primary goal of the Act is wage replacement, certain portions of the Act serve other purposes, And it goes on, it specifically references Section 33, the death benefit, Section 28, double compensation, Section 31, minimum weekly wage, the section dealing with disfigurement. Now here, benefits were paid for the death benefit. What happened was that after the death of Christian, CVS paid a bill, something on the order of $14,000 odd. Within the insurance program that it participates, CVS was reimbursed for the statutory amount of the $4,000. Judge Prasad, in hearing this case, specifically made reference to that. That is covered by the affidavit that was supplied by Ms. Bushy, the representatives of CVS, deeply involved with insurance matters. But what we have here is a situation where if we were to have 6.5 million people in Massachusetts, probably several 100,000 of these individuals are young people, adolescents who are working part-time. In the great majority of the cases, the parents are not financially dependent upon those children. And what we're saying here is, if you have a child who is injured, then the parents who are not dependent would have the ability to bring a common law action seeking loss of consortium damages. That would entirely undermine the Workers' Compensation Act, its provisions, and the intent of the legislature. We can see that this court has regularly referenced the exclusivity importance and the exclusivity bar in St. Germain, in Russell, in Foley, in Green, Peerless, Nutting, Brown. All of those cases have dealt with the exclusivity bar that is applicable, and we say is applicable here. The fact that weekly wages or weekly indemnity payments were not made has no relevance to the situation. The Act has its provisions. As it turned out, one feature of the Act did make a payment or cause a payment to be made.
And that was the death benefits?
That was the death benefit.
And what was the total there?
$4,000.
That's all?
That's the statutory cap. In fact, CVS paid the entire funeral expense, which was $14,000 odd, and then internally within the workers' compensation program, the $4,000 statutory amount was reimbursed to CVS. So a payment was made under the provisions of the Workers' Comp Act.
Mr. Daly, could you help me out? In light of your interpretation of the statute and Russell, which interpreted the statute, as you correctly stated, can you help me understand why the legislature would have segregated out next of kin who were financially dependent, but which presumably means if you're next of kin, and I'm not suggesting, that I agree or disagree as to whether they are or not in these particular parents, but if they are next of kin and they have a cause of action and they're not financially dependent, presumably if you're not the parent of the spouse, next of kin is one removed, why would your cause of action survive?
If you were not dependent, Your Honor, why
Yes.
would that cause of action survive?
Correct.
We say that it does not survive, obviously.
Well, of course, but I'm just saying, assuming that I accept your interpretation,
Right.
correct, that these plaintiffs, these parents were parents, not next of kin, right?
Yes.
A, and B, that the dependent on language is limited to next of kin. I'm trying to understand why the legislature would take a category of people, not in this case, next of kin, and say, if you're dependent on the employee, on the worker, you don't have any cause of action. But if you're not dependent on the worker, you do have a surviving cause of action.
Well, I think when you look at that situation, it would make sense. Let's say that we had a situation where next of kin were financially dependent upon the injured employee or the deceased.
A sister.
A sister. And let's say the sister was dependent upon the employee.
Right?
It would make sense that that sister would receive benefits
No, I understand
because
that.
of the need.
Right, but I think the question is, the sister, let's assume there's a next of kin who isn't dependent.
Right.
This exception in the statute would seem to suggest that if, for some other reason, she had a loss of consortium claim or a,
Some
negligent
claim.
infliction of emotional distress claim or something that arose out of what happened to the employee, this would suggest that she could bring that action.
No,
Because she would not be barred because she was not dependent on the brother.
But the exclusivity provision would come into play, Your Honor, and the fact that there was insurance maintained that addressed the accident would allow the employer to raise that as a bar. Now, you just can't say that someone who is financially independent automatically has a right to bring an action. I mean,
Well,
that,
it's not.
It's not a workers' comp action.
Yeah, it's not a workers' comp
Let's say it's a twin.
no, but it's a situation where you would be avoiding the exclusivity provision, and basically the employer would not have the benefit of having the workers'
Yes,
compensation
but the
covered.
statute seems to say that the people who have waived their right to bring such an action, when we're talking about next of kin, are only those who are financially dependent on the employee. So if you're a next of kin and you weren't financially dependent on the employee, this would seem to suggest the negative pregnant of that is that you can do it.
Well, I think there is case law that indicates in that very instance that that would not be the situation, that it wouldn't make sense to exclude financially independent people, next of kin,
from the exclusivity.
from the exclusivity.
Yeah.
I mean,
That's why I asked you the question. So-
Well, and I think that's the answer. And I think when we look at Russell and we look at the other cases, it is very clear that this court has indicated that that provision is going to be construed very narrowly, and that the question whether or not someone who is financially independent would have a case would not be the situation. Rather, the exclusivity bar would apply.
But does the non-dependent next of kin lose the right to bring an action for wrongful death because of Chapter 152, Section 24, or is it because of Chapter 229, Section 2?
Well, in 229.2, it specifically provides that a claim arising from an employment situation is not going to be the subject of a 229 Section 2 claim. It specifically provides that in the statute. And the effort that is being made here to bring this claim is specifically under 229.2. Let's say that someone is financially independent and somehow they could bring an action against an employer. I think you quickly go into the provisions of 229.2b, and I believe it's 6c, and that would indicate that there are significant restrictions on what can be brought and what relief can be obtained. And in 2b of 229, it specifically mentions dependency. So I think we have to read those two together to get a feel for what the legislature is trying to do here. We can also see that the intent of the legislature all along has been to include individuals. For example, we have seen that work-study programs involving students have been made subject to the Act. We can see that special police officers on detail are subject to the Act. We can see that nannies, for example, working more than 16 hours a week are subject to the Act. We can see that the legislature has been attempting to include individual employees because of the certainty of having benefits available. In other words, there's no question about fault, there's no question about foreseeability. Rather, it has been said that the benefit of the Workers' Compensation Act is such that it makes benefits available regardless of any negligence on the part of the employee. I also want to mention there is a suggestion here that the Act somehow is violative of Article 11 of the Declaration of Rights in Massachusetts. And in the Decker case, it specifically indicates that whether or not a statute bears a reasonable relation to a permissible legislative objection is the question, and Decker specifically found that the Act did serve a public purpose. I see my time is up, Your Honor. We would ask that the judgment entered in the Superior Court be affirmed.
Thank you, Mr. Daly.